Court Watch with Alex Swoyer, and I'm excited to bring you the 8th episode of my podcast where I was joined by Curt Levey, president of the Committee for Justice, who gave a thorough rundown of this term's top cases. We anticipate major rulings on race, religious liberty, voting rights, social media, and gay rights, all to come down in the next few weeks. Mr. Levey is an expert court watcher who has worked in the past on Supreme Court cases. He joined me for a chat about which cases he's monitoring this term, starting from the first major oral arguments that took place when the term kicked off last October until the most recent arguments last month. Hey, Curt, thank you so much for taking time to join my podcast and basically let our audience know the major rulings to watch out for. It seems like May 11th might be the next opinion day, just kind of the court mentioned at the end of oral arguments in April that was going to be the next date they gavel in. So I'm thinking that could be when we start to see some of these major opinions roll out. What ones are you specifically watching and looking out for? And also, I think one of them is going to be what this court does with the Biden student loan case. And do you think that could come sooner rather than later, given that it's kind of on hold?
Well, I certainly hope we get some important opinions on May 11th because there's been a dearth of those so far. I mean, the only one that was really important was the FTC case, which basically had to do with whether you can challenge, whether you have to stay within the FTC's administrative proceedings, or if your arguments include the idea that the structure of the FTC is unconstitutional, whether you can go to the Article 3 courts and challenge that, and the court unanimously said that you could. And that is important, especially with all the fighting about power of federal agencies of late. But that's really the only important one that we've had so far. As to the student loan case, that was argued relatively late in the term, so I'm guessing we don't see, I think it'll be well into June before we see, a decision there. Maybe the most important of all cases are the ones that'll sort of be, the equivalent of Dobbs in terms of the attention they get, are probably the Harvard and University of North Carolina affirmative action cases. And I bring those up because those were argued very early in the term. Mm-hmm. And so, if there's going to be a surprise where we see, a decision before June, that may be the one. So, but in any case, if you'd like, I could just go through, sort of it chronological order by which they were heard.
Let's do that.
Go through.
That sounds good.
So I'm looking at a long list of cases, but I'll pick out the ones that I'm really following.
One of the early ones is Moore v. Harper, right?
I forget when that was argued. Wasn't argued as early as Sackett v. EPA.
Right.
Which, again, if you're interested in sort of the power of federal agencies, that's an important one. And the Committee for Justice, my organization, filed an amicus brief in that one. And that's really about, what's the right test for determining when wetlands, and that's probably overstating it, could be a puddle on your property, are called waters of the United States, which is, what the statute refers to, the Clean Water Act. And, if it was up to the EPA, literally every, persistent puddle on your land would be waters of the United States, because somehow, water flows underground between your puddle and some other body of water.
So I was going to tell you, I didn't cover this case. It was one of my colleagues who did, because she had actually I started covering this years ago, talking to the family that brought the case, right? Like, I think they bought a plot of land and they haven't been able to build on it. Is that what it was? For like 15 years.
Yeah.
So she had interviewed the family previously. So I actually can't tell you, I usually like to leave arguments having an idea or not an idea of which way the court was leaning. So I can't really remember, the gist, but like you were saying about the court seems willing to crack down on some of these agencies. What's your take?
I think it'll be better than the current test, which is just talks about a substantial nexus. But again, that nexus could be water, flowing underground. The plaintiffs would like to see something like there has to be a surface connection. not that, somehow my puddle influences, your pond 2 miles away. So I think the court will give us, a better definition. I can't necessarily tell you, exactly what that'll be.
Yeah, so could clarify the EPA's reach is kind of what we're going to find. I think
that's a good way to put it. Another case that was argued very early was Merrill v. Milliken, and that's a voting rights case coming out of Alabama. And that really, the issue at stake there is the Voting Rights Act has been interpreted very broadly. It certainly prohibits discrimination against minorities, so you can't draw your district in a way that purposely tries to minimize, say, black representation. But the Voting Rights Act has been interpreted so broadly that you have to do the opposite, that you basically have to gerrymander to create as many so-called minority-majority districts as possible, i.e. ones that will elect, black representatives. And that's really, if you think about it, sort of, racist. I mean, the idea that you have to draw lines in a race-conscious way. It really
right. I think that if I remember right, you can tell me if I'm wrong, but I think they have one majority black district, and they were saying that the population, though, is, I guess, more than a quarter black.
Right.
So it should be more, that's I think their argument.
Right. But that, doesn't make a lot of sense because, if the black population is evenly distributed, then it's not going to be a majority in any district. It may already be, I don't know the facts well enough, but it may very well be that they already went out of their way to create one black district. But, the plaintiffs think there should be 2 black districts, so which would be roughly a quarter of the number of congressional districts.
Did you, I don't remember, I covered it, but I can't remember having a clear feeling about the way the justices were leaning on that one.
Again, I'm going to guess, I don't remember the argument either, but I'm going to guess that, again, I don't expect the court to completely throw out the idea that, you should certainly give some consideration to maximizing the number of minority-majority districts. But on the other hand, I don't expect them to affirm the district court. I suspect that they will. I suspect they'll reverse the district court, but not completely get rid of the idea of maximizing minority districts.
Okay.
Anyway, that's just my guess based on the composition of the court and what little I remember about.
Yeah, I know. I was going to say, I keep trying to remember the oral arguments. This is what happens when there's so many. I mean, I do feel like this year had a lot of big cases. But okay, go ahead.
One case, I don't know how much the public is paying attention to this, but the National Pork Producers case.
Oh, yeah, I did cover that one too, right? And so that one's about, just to refresh the audience memory, raising pork in California, right?
Yeah, I mean, it's dormant commerce clause, which is probably going to cause people to snooze when I say that. But a better way to put it is it's another example of California trying to push its weight around and, in a sense, tell everyone in the rest of the country what to do. So basically, there's a California law that says that if you sell pork in the state, it has to have been raised in conditions that are very favorable for pigs. And look, I'm all in favor of
animal rights,
treating animals well, but this is, at the end of the day, it's not about animal rights. It's about whether one state can really try to control interstate commerce.
What I remember, one of the things that kept coming up was, although the pigs might be raised there, they end up being, I guess the meat can be then sent to another state to be, Yeah,
very few, again, I don't know the statistics, but the vast majority of pork consumed in California is not raised in California. If California wanted to regulate how, pigs that are raised there, just in that state, can be treated, then then there's no dormant commerce clause issue, and, you wouldn't have the case. So again, I don't remember oral argument well enough to guess how that one's going to go. One that I'm particularly interested in from early on because Committee for Justice filed an amicus brief is Warhol v. Goldsmith.
Mm-hmm.
And that basically involves a photograph of Prince when he was up and coming, which Andy Warhol made some silkscreen images of. So they're not photographs, but they otherwise exactly follow the outline of the photograph. And the question is whether the use of those silkscreens had to be licensed, or whether there's fair use, which is an exception to copyright protection. And there we basically side with the photographer Goldsmith. And that's, again, I don't want to get too much into the weeds, but a lot of these copyright cases come down to fair use, and fair use in recent decades has been based a lot on whether the so-called infringing work is transformative. So, one way of putting that is if you add a lot of artistic flair to it, and you really mean something very different from what the original creator meant. And, the obvious example there is parody, where you're not copying. You're, quite the opposite, usually making fun of. Here, if you really look at the two, it is copying. And, we're for reasonably strong intellectual property protection. And so we don't want to see, the transformative factor become basically a license for anyone to infringe. So
right.
I certainly hope that Goldsmith wins, but it's hard to tell from oral argument because this doesn't break down along easy ideological lines.
Right. I remember.
Some of these cases, you just look to sort of what Roberts or Kavanaugh, the swing justices feel, and you can kind of predict what's going to happen. But it's not even clear to me who the swing justices are in that case. So I'm not going to guess. And then the cases that I briefly alluded to earlier, the Harvard and University of North Carolina cases that were argued, I think it was in November. Those, again, are very near and dear to my heart because I was part of the legal team that brought the Gratz and Grutter challenges to race-based admissions at the University of Michigan. It's almost 20 years. Well, it is 20 years because it was 2003 that those cases were decided, and it was more a loss than a win for us. They did strike down the admission system at the college and upheld the admission system at the law school, even though it was using race as just a bigger factor, but it was doing it in more of a touchy-feely way than you get 20 points for being the right skin color the way the college was doing. And but in any case, I say it was more a loss than a win because the court did say that you could use race under the cover of it being one of many diversity factors, where diversity doesn't really mean skin color, it means intellectual diversity.
I remember.
The idea is that.
Yeah, go ahead.
Go ahead.
I was going to say, I remember leaving the oral arguments and talking to some of the other reporters, and the vibe was that it's going to go away.
It'd certainly mostly go away, at least officially. I should also point out that Students for Fair Admissions, which were the plaintiffs who were representing Asian students who, in recent decades have been hurt even more than white students by affirmative action, just because there's a lot of schools that if they didn't engage in race-based admissions would be, especially in California, half Asian, and they just don't like the look of that. Just like they don't want to have too few Black or Hispanic students, they don't want to have too many Asian students, and it's reminiscent in many ways of what happened, almost 100 years ago with Jewish students, where the schools in those days, that was before political correctness, the schools were quite schools were quite, sort of honest about what they were doing. I mean, they were basically saying that, what they really didn't want is, 25% Jews, even though they were just 2% of the population. And so they talked, in somewhat similar terms. We need a more representative student body. And so they found various ways to, roughly cut the number of Jewish students in half. And, there was no checkbox for whether you were Jewish, but they could tell very often by your name. And, they used very many of the same arguments that we hear from these schools today. Now, given 100 years, we can all agree that limiting the number of Jewish students was wrong. But, somehow, because we're in the middle of it, it's harder for some people to accept that limiting the number of white or Asian students is wrong. I think everyone agrees that it's not going to be good news for the universities. I certainly hope that the court is clear in getting rid of the diversity rationale, the idea that while you still apply strict scrutiny to racial classifications like this, that that the exception is always if there's a compelling interest, and that the educational benefits of diversity are a compelling interest. I hope they get rid of that. It's largely a fiction. I mean, that's not really the reason that anyone wants race-based admissions. I mean, it's really about proportionality, wanting more.
Right. That's kind of what they got at, like from, I guess, previously, I think Sandra Day O'Connor had suggested, like in so many years we wouldn't be here, but we're like almost to that point where she suggested. And so the question is, I think the court kept asking, like, when will diversity be met where this won't be?
Yeah. Look for, people argued whether it was dicta at the time, but the majority opinion in Grutter did say 25 years, and now we're at 20 years. So I think the court, if it does basically get rid of the diversity rationale, it will definitely cite that 25-year limit. I mean, who knows? They may even say you've got another 5 years. But arguably, they won't even be overturning precedent because Grutter did mention the 25-year limit. And the idea there is that racial preferences were a way of evening the playing field. They weren't meant to be a permanent fixture, and they've become a permanent fixture. And I think the court is not going to be happy with that. But again, we'll see. And there's going to be probably almost as much screaming after these cases from the left as there was after Dobbs. Hopefully they won't be leaked. And then let's see. I'm not sure how many people are following this, but there's if you're a law nerd at least, and you care about personal jurisdiction, there's Mallory v. North Fork Southern Railway. I won't get into the details, but again, for law nerds, that actually is an important case. It involves whether you can require a corporation that does business in your state to consent to personal jurisdiction in your state. I'll leave it there. There's also the Health and Hospital Corporation of Marion County, Indiana. That's also an important case, if maybe a little bit nerdy. There's a lot of so-called spending clause statutes, which basically says if you don't, Title IX is one of those, by the way, where it's basically about you'll lose federal funding if you, don't behave the way the government wants you to behave. But courts often read into those spending clause statutes private rights of action. So, again, Title IX says nothing about an individual being able to sue. But, the courts have read that into Title IX. And that case is basically about, when can the courts read a private right of action into a spending clause statute. And it's actually quite important. And, plaintiffs' attorneys, certainly like the idea that you can always read a private right of action into a spending clause statute. And on the other hand, if you're not a big fan of plaintiffs' attorneys, you're certainly hoping that the court will put some restrictions on. And again, the court's not going to say that you can never read a private right of action into a spending clause statute, but hopefully it'll put some limitations there. There's Palin v. Brackeen, which again, maybe a nerdy case. I mean, it involves the Indian Child Welfare Act, which says you have to give preference when placing children to, Indian families.
Right,
but and there is a equal protection argument there. But there's also a 10th Amendment and, the so-called anti-commandeering practice about, the federal government telling states how to do things. That's that issue there. So that should be of interest to, people who are interested in Indian law, like Gorsuch.
Right.
People who, care about race-conscious decision-making, and certainly people who care about federalism and the 10th Amendment and adoption, like all of those. And I think that wraps it up for November. And then in December, we did have Moore v. Harper. And that's a very important case. That's the so-called independent state legislature theory, which is based on the fact that the Constitution says that it's the state legislature that should specify the time and manner of electing representatives to the U.S. House of Representatives. And, people say,
just to refresh
really
everyone's memory, it's about the congressional maps in North Carolina and how the GOP legislature had drafted their maps, and then state courts overruled that and implemented their own. And so it's basically, can courts get involved, have a say in this, right?
Exactly.
Yeah.
Right. And not really can courts do it, but can state courts do it.
Right.
Under the Supremacy Clause, federal courts can definitely do it. And, so I think, again, the left, detest the idea of the independent state legislature because they like
going
judicial activism. But I think they're sort of overstating the threat because federal courts are, plenty happy to be judicial activists. So it's not like they're just going to have to go to federal court instead of state court. But the question is whether, the Supreme Court's actually going to decide this case because it asked for additional briefing.
I was going to ask you what you thought of that. They asked for briefing on jurisdictional issues because now that the Supreme Court of North Carolina became a majority Republican, they're rehearing this case, right?
They reheard it. They haven't decided it yet. And so the court asked for briefing on basically the final judgment rule, which is that, appeals are supposed to be from final judgments. And is the old, more liberal North Carolina Supreme Court, when they struck down the redistricting plan, that was a final judgment. But now that it's up in the air again with the new North Carolina Supreme Court, is that a final judgment? And, there's various exceptions to the final judgment rule, which I won't bore your audience with. But I think there's at least a 50% chance that they throw this case out, that they, dismiss it as improvidently granted.
Right. I think they'd like to not have to decide it. They have enough on their plate anyways,
probably, right? I think, you might have a majority in the court that's sympathetic to the independent state legislature theory. On the other hand, it is controversial and, even the justices that like the theory may not really want to.
I remember leaving oral arguments and thinking that the GOP lawmakers had a hill to climb. So they might end up actually being happy if they don't decide it based on the vibe of the oral arguments. Yeah,
I had the same vibe that, again, maybe there's a way of splitting the baby on this. And people have proposed various ways of splitting the baby, but very unlikely that this is going to be, a complete victory for the North Carolina legislators.
Mm-hmm.
And then around the same time, there was an argument in 303 Creative, which basically involves a woman who designs websites and didn't want to do it for a gay wedding website. This is sort of a follow-on to Masterpiece Cake Shop,
right?
Which was a narrow ruling.
This is though, I think they're saying like it's a challenge to the public accommodations law in California that says, you can't discriminate on, I guess, the basis of like sexual orientation. But what's interesting, I guess, different than Masterpiece Cake, I think they made religious claims, right? Like both, like this is focused on speech because she's saying you would compel me to like design wedding websites for same-sex marriages, and that's against her religion. So
they've been careful to sort of put the focus on
speech.
Expression, yes.
Right.
Rather than religion. Although I think, the public views this as another battle between anti-discrimination law and, religious liberty.
Exactly. Yeah.
And, in Masterpiece Cake Shop, the court gave conservatives a narrow ruling, which, I don't think left them really satisfied.
Right.
So,
there they said the baker didn't get a fair hearing in Colorado when he was brought to court by a same-sex couple that said that he refused to bake a wedding cake for their ceremony.
Exactly.
Yeah. So he's still in court fighting that out because they didn't rule directly on the issue. Do you think they'll do it this time?
I think so. My gut, based on oral argument and, again, the composition of the court, which is more conservative than when it decided.
Right.
Masterpiece.
Kennedy was on the court then.
I think that that the website designer will win this case.
Mm-hmm. I will just add, they were very focused on the idea of trying to possibly draw a line during oral arguments about those that provide a service versus I guess custom work.
Yeah, right. The website designer wasn't claiming that if she was selling, some
template.
A template, something where there was no expression involved, or if she's selling key rings, whatever, just some product, where there's no individual expression, then that the Colorado law would apply. So yes, this really is limited to where there's a lot of individual expression involved. Then there's also a bunch of immigration cases. There's U.S. v. Texas, which is, if you remember, a couple of years ago, Homeland Security Secretary Mayorkas issued a new policy that basically said, well, we can't deport everyone, so we're just going to, do it for, limited number of categories, such as, people who have committed crimes or suspected terrorists. And, that was basically throwing up their hands and saying they're not going to enforce the law with regard to other illegal immigrants. And so some conservative states, I think it was Texas and Louisiana, sued. And, like a lot of these immigration cases, it's basically a challenge under the Administrative Procedures Act that says, that in a sense doesn't go to the substance of the policy, but just says you didn't follow the proper procedures in adopting it. But even for people who don't care about immigration, there's, interesting standing issues here. And, certainly the decision could have, implications, not just for immigration policy, but, also just in general for the, how easy it is to challenge federal regulations and executive orders, and whether, the states bringing the suits is the right vehicle to do it. So that's definitely one to watch. Another very important pair of cases are Gonzalez v. Google and Twitter v. Tamna.
I would say I think those are up there with the affirmative action case in terms of what our audience has been interested in.
Yes, certainly Section 230, both the right and the left dislikes it. It basically, immunizes the internet platforms against most types of lawsuits.
Yeah, so these are two cases brought by victims, families that had loved ones die in terrorist attacks, and they've sued big tech companies saying they've either, they're either algorithms, I think is one issue in one of the cases, contributed to basically ISIS recruiting and whatnot. And so they challenged Section 230 of the Communications Decency Act, which immunizes, like you said, tech liability on these types of platforms where third parties post. And then on the other side of it, I think it was the Twitter case, that was more focused on an anti-terrorism act statute, saying they aided and abetted the terrorists.
Yeah.
So,
yes. They both involve ISIS videos.
Exactly. Right.
And
there was a lot of overlap during oral arguments. Yeah.
Technically, they're about different things. The Gonzalez case is about whether Section 230 still applies if the platform targets these or recommends these videos or really any third-party content to users. And the court seemed very focused on whether those recommendations were made in a neutral way or in an ideological way, for lack of a better word. For example, if the justices seem to be a majority who agree that if it's just an algorithm that says give people, more of what they already like, that probably does fall under Section 230. Whereas I think everyone agreed if, in the extreme case, if Google were to have a policy of, we like ISIS and we're going to promote it, that would not, not that Google does have that policy, but in that extreme case, Section 230 would not protect them. So, I think this is mostly going to be a win for the platform. Certainly people who are hoping that this will get rid of Section 230, which is both the right and the left, that's not going to happen. But it might, slightly limit the immunity that the platforms have. The Twitter case, although it doesn't directly involve 230, it still is about that sort of line drawing where they, the plaintiffs claim that a few of the tech companies, I think it was Twitter, Facebook, and Google, which owns YouTube, didn't do enough to prevent ISIS from encouraging terrorism. And again, that's going to be about line drawing. I mean, there's no doubt that at some point, and by the way, we're talking about the Justice Against Sponsors of Terrorism statute. And, there's no doubt that at some point, if these platforms were really promoting ISIS, that they would be liable under that statute. But so it's about line drawing. But again, I think in this case, where it really was just, recommendations based on what you already liked, and where there's no obvious connection between those videos and the terrorist act, I think the platform is going to win that one.
I remember leaving both of those thinking that the court wasn't going to touch 230 and that possibly they would try to find some accountability under like the terrorism statute, only because they kept going back to this idea of like, how long was social media or like Twitter aware of this content on its website and didn't do anything? I guess they were saying there was references to like news articles, interviews about them being pointed to like the content, that sort of question, like, oh, well, once you were put on notice, I don't know. So we'll see. We'll see. To be continued.
To be continued, yes. But you're right. That's certainly going to be, again, if only because it sort of stands for the larger debate about the dangers of big tech. I think it'll get a lot of publicity, as will the student loan cases, which you mentioned. There were two of those, and they differ. Well, I guess I should back up and say that the Biden administration, there was no statute that gave this debt relief. So instead, the Biden administration used the HEROES Act, which is really targeted to military personnel and really, is not about debt cancellation, but about, postponement of debt. But, they stretched it and, forgave, depending on your situation, $10,000 or $20,000 of debt relief, which, adds up to a ton of money across the country. This case, will be interesting not just for whether the court strikes down that debt relief, but, also for the fact that if they do strike it down, they'll probably use the major questions doctrine, which has been, gaining strength in recent years. That's the idea that when, on major questions, agencies do not get the same deference that they do on minor questions. And that makes sense. If there's a statute that, refers to, I don't know, the octane content of gasoline, then, let experts at, the EPA or whatever agency, determine what's the right level. But when you're talking about major questions about, whether we're going to have massive debt relief, something that if we're going to do it should be done by Congress, agencies don't get a lot of deference to make stuff up.
I think that so the my understanding is like it's no debt has been forgiven yet. It's been proposed, and so that lower courts had put that on hold. And so one of the things, I know it was argued late in the term, but I kept thinking maybe it would be one of the earlier ones we get, just because, I guess borrowers are probably waiting to find out what they're going to start paying back once repayment begins post-COVID, right?
Yeah, I mean, there's not a real urgency. So again, my guess is probably not
June.
until not until June. And there's also standing issues there, and those are different between the two cases. And one of the cases about whether the states that sued have standing, and in the other case, it's about whether a
borrowers,
couple of student loans. Well, and it was hard to find plaintiffs here because again, you have to show injury, and arguably, there's, how are you injured by other people getting debt relief? There's not general taxpayer standing. I mean, that would be the obvious argument that as a taxpayer, this is going to cost me money. But the courts have been clear that there's no general taxpayer standing. So it was a bit hard to find plaintiffs, and it is possible that these cases will ultimately be dismissed based on standing. Again, my guess is that won't happen. They might say that the two student loan borrowers, that they don't have standing, but I suspect that they'll say that the states do, and then they'll go to the merits. There's another immigration case, U.S. v. Hansen, which is actually a First Amendment case when you really get down to it, because there's a federal statute that prohibits encouraging unlawful immigration for any sort of financial gain, and the argument there is that it's an overbroad law, which is one of the ways that things get struck down on First Amendment grounds. There's another interesting intellectual property case, the Jack Daniels case, which is basically where a company made a dog toy, which is kind of, looks like a Jack Daniels bottle, which is very distinctive, and it's
the
similar. The
question is, are you going to confuse the two? Do you go to PetSmart to get your liquor?
Yes. That's certainly the argument that the dog toy manufacturer makes. But, Jack Daniels argues that there's, that you're basically diminishing, in a sense, the brand by making fun of it. And again, I won't get into the details, but it's similar to the Warhol case.
It does say something like the dog toy says something like number 2, like,
yes, it's right. There's a lot of
poop references, humor. I guess.
Yes. One of the briefs, I think it was the Jack Daniels brief, had cited to various children's books about poop. So yeah.
Yeah, it said something. I remember reading one of the briefs that said something like a dog poop toy. I was like, poop toy? What is a poop toy? And then I had to look at the actual images, and I was like, oh, that's what they're getting at. I got what they're referencing now.
But it's about can you infringe? In this case, can you trademark? But can you infringe if you're doing it in some artistic way? So that's basically the issue there. There's also on the IP front, there was the Amgen case. Again, I won't get into the weeds there, but it's basically comes down to, there's this requirement in patent law that you have to give enough details such that somebody skilled in the art could make and use the claimed invention. And the idea there is that in return for patent protection, you have to sort of explain to people, how to use your invention. And, it has to do with sort of just how broad that requirement is. It basically involves pharmaceuticals, and I won't get into the details. There's the Groth case, which is also religious liberty. Up until now, the requirement for employers to accommodate you based on your religious needs was, very small. If it was more than a de minimis cost for the employer, they didn't have to do it. And that's at odds with, say, disability law, where any sort of reasonable accommodation is required. So question is the court going to
and that's what it was a former post office worker who said that the post office wasn't accommodating his request not to work on Sundays. based on his religion. Yeah. And so we'll see. I mean, that one's going to be one I left leaving those oral arguments not really sure what the court was going to do there.
Yep. I agree. I mean, I actually personally hope that the court does have the same standard for religious accommodation that they do for disability. It strikes me as sort of unfair not to, and in a sense, I think it reflects the decision that, makes it just look at de minimis cost is, like 50 years old, and I think reflects a time when there wasn't a lot of attention paid to religious liberty. So I hope the court does say that, there's more of a burden on the employer than just, like I say, the burden to do more than just something that has a de minimis cost. So anyway, we will see there.
To be continued, right?
to be continued. Then the case that was just argued, I think it was yesterday, was the Tyler v. Hennepin County case.
Yeah, I was there. It was interesting.
That's an interesting one about, when the government takes your, home to satisfy a debt. What if the home is worth more than the debt?
Right, right. Who gets that money?
And that, involves, I guess, the argument in that case is that, if they keep more than what you owed them, then that's, a violation of the takings clause. And I did not listen to that oral argument, so I don't have a guess. Do you have a guess as to what the court will rule?
I left feeling like they were sympathetic. So the woman who brought the case is 94. Her condo, I think it was sold for $40,000. She only owed $15,000. The state kept the rest, or the county kept the rest. And they seemed sympathetic to her. I guess the questions, the middle of the court, like Kagan, for example, and Barrett kind of asked, maybe it was Barrett or Kavanaugh, I can't recall, probably Barrett, jumped on this idea of what if it was a $5 million house and your debt was $5,000? Does that still mean, the county could keep the surplus? So is the idea of, is there a limit on this?
Which, would seem ridiculous that, they could keep your $1 million house or a $5,000 debt. But, so I hope you're right that the court was sympathetic. And then I guess the last case we should mention, it wasn't actually argued, was another immigration case, Arizona v. Mayorkas, which, if you remember, well, first of all, it involved Title 42, which is about to be lifted by the Biden administration. And it was about not the merits of the case, but whether various states, could intervene in the case and basically, assert that Title 42 should remain in place. And, maybe a couple of weeks before it was going to be argued, I think it was at the beginning of March, it was supposed to be argued, they took it off the calendar, but they never dismissed it. Now, they may just be waiting. I suspect they're probably just waiting for Title 42 to actually be lifted in a couple of weeks, and then they'll dismiss it. But it's worth mentioning because at least before they took it off the calendar, it was a high-profile immigration case.
Mm-hmm. Well, we'll have to keep watch.
And, I went through the whole list of sittings there. And
pretty quickly, given how many cases. I mean, usually we have a few we're watching, but I feel like this, is it just me, or is this year, is there more than normal?
I think because the court's only decided, the Axon VFTC and its companion case, those are the only major ones that they've decided. I think that's why it feels that there are a lot of important ones. But, certainly the affirmative action cases are, again, as bigger cases as you're ever going to find. So I do think it's going to be, the last couple of weeks of June are always exciting, and they'll probably be even more exciting than average. And, the court's probably just, running behind because of, human nature to leave everything to the last moment. But, I suppose it could be a strategy that if you announce a bunch of controversial decisions, within a space of 2 or 3 days, people can only focus on attacking you on a couple of those. So
right, knows? Right before, release it right before July 4th when everyone's out of town.
Yeah. Right, exactly before the justices get out of town. So who knows? Maybe there's some strategy there. And again, let's always leave open the possibility that we'll have a surprise that some of those big cases will be decided a little bit earlier. Than the last couple of weeks of June. But
they usually close at the end of June, but they have been going into July more recently, a little bit, like the first.
Yeah,
first
they've
week.
been going. They'll typically, whatever that last week of June is, if that last week runs into July, they'll go up to that Friday. So I haven't looked at the calendar, but they're always done by July 4th. So.
Yeah. Well, I appreciate your time, Curt. Thank you so much for breaking all these down for us. I'm going to do a story on all of these, and I want to make sure I get it out before, like I said, I think we're going to start seeing opinions, at least from what I got from the court. It looks like maybe May 11th. So this could all change, right? We could be surprised. We could get a big ruling then. Who knows? Yeah.
Again, given how many cases we just went through, it wouldn't be a surprise if a couple of them, come before June.
Mm-hmm. Well, thank you again for your time. I appreciate it.
All right. You're very welcome. Take care, Alex.
All rulings are expected to be issued from the court by the end of June before the justices head out on their summer recess. Thanks for tuning in to the 8th episode of Court Watch. I'll have another episode for you at the end of the term breaking down the most crucial decisions. If you have not subscribed yet to my podcast, please do so and feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.